And then we have Roger Colinvaux, who's professor of law at Catholic University's Columbus School of Law. From 2001 to 2008, Professor Colinvaux was legislative counsel with the Joint Committee on Taxation, and he played an important role in crafting the charitable giving and reform provisions of the Pension Protection Act of 2006. Prior to joining the Joint Committee, he was a tax associate at Arnold and Porter, and he taught as an adjunct at Georgetown. He has testified before both houses of Congress on reform issues relating to tax-exempt organizations and is often cited in the press for his expertise. His scholarly writings focus on the charitable deduction, including conservation easements, political activities of tax-exempt organizations, and the nonprofit sector generally. He arrived later than expected to Salt Lake City last night because he was testifying yesterday before the House Ways and Means Committee on their hearing on proposals to modify the deduction for charitable contributions.
Good morning. I think it's still morning. No, it's afternoon. Sorry. I don't know where I am. Good afternoon. Well, my task today is to talk about reform, but in order to talk about reform, I also need to talk a little bit about why there is a need for reform. And I do believe that there is a need for reform in this area. I might have to go over a little territory that both Nancy and Ted covered, but, and I apologize, my PowerPoints are not nearly as nice as Nancy's PowerPoints, but they might help you and they'll probably help me as we go along. I just wrote them up this morning, so they have my own abbreviations in them. But first of all, if I were to call this presentation anything, it would be that conservation easements are exceptional, and they're exceptional in just about every way. And first of all, they are exceptional in terms of being successful. So they have, in fact, fueled the rise of the land trust community and seem to be at least indirectly responsible for over millions of acres that have been put underneath easement protection. They're also exceptional in that a lot of money is involved here. So we know that there's more than $1 billion worth of claimed contributions each year. It has been estimated that over a 6-year period, a revenue loss of about $3.5 billion. And that does not include corporate activity, so the revenue loss is actually higher. It is also exceptional in that conservation easements are the best treated conservation contribution in the Internal Revenue Code. There's no better deal. So in 2006, not only do you get the benefits from the deducting the unrealized appreciation, but also in 2006, Congress enacted special rules that give better percentage limitations and also better rules for carryovers. So this is an exceptional benefit. The history of easements is also exceptional. Now, before 1969, the general rule was that you could deduct an easement or deduct the fair market value of an easement. There weren't too many easements around in those days, and somebody, I suppose, had one and thought, gee, what do I do with this? Maybe I'll give it to charity. And then the IRS said, well, I don't know. Can you deduct that? And the answer is yes, you can deduct just about anything you give to charity, and if it's property, you get to deduct it at fair market value. But in 1969, Congress changed the rules, and as Ted said, it was a very important change. They barred partial interest contributions, and this would have eliminated the conservation easement deduction because conservation easements are contributions of a partial interest. You're only giving away part of what you have. And so in order to have the deduction, Congress had to create an exception in the law. First, the exception relied on legislative history. Then there was a temporary provision in 1976, which became permanent in 1980. But this was against the advice of the Treasury Department. Now, it's important that these rules are also exceptional. It matters, it really matters that this is an exception to the partial interest rule, and I don't think it can be emphasized enough, because without the exception, there would be no deduction for these easements. As Ted said, the reason for the partial interest rule include valuation reasons and conflict of interest reasons. And the conflict of interest is interesting because what it means is that there are two owners. So you have the owner, the charity on one side, and the owner who's the person or the tenant in possession. But when you have two owners of the same property, there could be a conflict as to use. That conflict as to use can also lead to valuation difficulties. How do we value a partial interest? How do we even know that the benefit that's promised to the charity is actually going to come to pass? So we have this exception to the partial interest rule, But what's notable is once you carve out an exception from a general rule, you have to confine that exception in some way. And so there are special rules that enable you to take a partial interest deduction. And the special rules are three as I look at them. One is that it's got to be to a qualified donee. Another is that the easement has to be for a conservation purpose. And the other is that it must be in perpetuity. So those three rules now also present exceptional enforcement challenges. And those exceptional challenges, I can break them out for each rule. The first one is this idea of a qualified donee. Now, normally when you give to charity, the charity is just, it's generically qualified under 501c3 or maybe under some other section. Well, in order to give a conservation easement, it has to be to a subset of those qualified donees. But more importantly, then, in the Treasury regulations, there's an idea that the donee has to have both a commitment to the easement and the resources to enforce the easement. Now, this is a different idea. It's not that you can just give it to the qualified donee. The donee also has to have a commitment to protect it and the resources to do it. Well, this Treasury regulation, however, is really a formal requirement. It doesn't have any teeth to it because you can say that you meet the commitment pretty much by putting words in your organizational documents, and there's no substantive requirement that you actually set aside any funds to make sure that you can protect the easement. Also, this presents an enforcement challenge because normally when the IRS looks at charitable organizations and polices them, it polices them for different sorts of things. It says, well, are you paying your insiders too much? Is there excess compensation? Is there private inurement? Are you operating for private interests? That's how the IRS enforces the law against donees. But here, there's no real sanction if the donee fails to enforce the easement. Another exceptional rule is this conservation purpose rule. We take it for granted, but if you think about it in the context of other charitable contributions, it really is different. It contemplates more IRS involvement. Normally, when you give property or cash to charity, you're done. The IRS doesn't place a condition that says, well, it has to be for a particular purpose, or you have to use it in a particular way. Sometimes we care about related use, that is whether the property is used for a related purpose, but that is a very different inquiry as an enforcement matter than deciding whether something is for a conservation purpose. This is meant to be a substantive test. The problem is that conservation purpose under the Revenue Code and under the regulations is very open-ended. It is outside the IRS expertise ultimately to determine. It is hard to enforce, and it is also hard to predict. It implies something on an ongoing basis. And then the other exceptional enforcement challenge is that it must be in perpetuity. We've already mentioned it, it's the elephant in the room, but if you just stop to think about what that means as an enforcement matter, right? Normally we get the deduction when you make the contribution. Well, a condition of deduction is that it be in perpetuity. You can say that on paper. Well, if it has to be in perpetuity, that means forever. So does that mean that the IRS stays involved forever? That's a pretty big enforcement challenge if that's what that means. So we have some unique challenges to enforcing the easement. The other is the other elephant, I suppose, and that's valuation, valuation, valuation. Yes, I believe the Treasury was absolutely right to be concerned about valuation, as all the cases have shown. Easements, there's no arm's length transaction, so the donor and the donee are not in an adversarial position. There's no sales market for easements, so we don't have a good comparative basis. Significant expertise is required in order to value these easements. It's extremely resource intensive for the IRS, as Karen has said, to figure out what the value of these things are. The before and after method of the regulations is very speculative as well as complex. And then there's another issue here which doesn't typically occur in charitable contributions, which is whether the donor has really given anything up at all. Normally, when we give deductions, we base the deduction on the fact that the donor has parted with something. When you give cash, you no longer have the cash. When you give valuable property, you no longer have the valuable property. So we base the deduction on the fact that you've given something up. Conservation easements are a little different because many conservation easement donors favor the conservation purpose and perhaps wouldn't have developed the land anyway. So they might not have given anything up of value to them. And this too would affect an enforcement challenge. So all these challenges then lead to areas for reform. Now the point of the incentive is to secure conservation benefits. The problem with the incentive, in my view, is that it does not facilitate a substantive definition of conservation. The result is that valuation uncertainties can be used to benefit donors, often for questionable conservation benefits, and the IRS does not have the enforcement tools it needs, leaving it to fight valuation battles, which leads to proposals for reform. Now, proposals come in a variety of flavors. Most are focused on one thing, and that is better conservation outcomes. That's really what people want to have happen. So there are a number of proposals, and I've got a laundry list here, but they really run the gamut from the extreme to the small. Maybe starting with the extreme, just because it's not extreme in the, but anyway, is to convert to a direct spending program. So we get rid of the conservation easement deduction, and instead we say, well, government, why don't you acquire the easements directly? You pay for those easements pretty much through an appropriation. That could be beneficial because if you have the agency purchasing the easements, there would be some sort of a competitive selection process, and government would be involved in the decision of what to protect and how the land should be protected. If you don't want to go that far into a direct spending program, you could convert the deduction into a credit. Now, a credit could be capped. So you would say, sure, we'll have credits, but only up to hundreds of millions a year. That's the most credits we're going to issue. And the credit could be administered not just by the IRS, but also by some other expert agency that knows more about conservation and can be involved in selecting the credit-eligible easements. Or if you don't want government to be that involved in the decision-making process, you could use a credit and let a private entity award the credit. So the private entity would have the credit authority and could decide which easements would be able to get the benefit of a credit. There have been a number of other proposals. One is to quite simply eliminate the deduction for facade easements or any easement on which there is a private residence, and this is partly because the possibility for private gain is too high. You could also reduce the valuation problem. There have been proposals that would provide for an automatic so-called haircut of the deduction as a percentage of the easement value. So you just say, well, if the easement's worth $100, you only get to deduct $33 of that. You could change the measure of the deduction so that it isn't based on before and after value, but it's based on some other more objective measure. There are other proposals that go directly to improving conservation benefit. One, which is surfaced in a number of different forms, is to require that all easements be pursuant to a government-delineated conservation policy. Right now, only non-scenic open space easements have to be pursuant to some government policy. Others have called that we should require some government agency to pre-certify the conservation value of the easements. As Nancy mentioned, the Treasury recently proposed that we should eliminate easements on golf courses. We could also improve conservation benefit by getting the donee more involved, by certifying the public benefit from each easement in relation to the tax benefit. This would put the donee a bit more on the hook for the easements that it accepts by attesting to their conservation value. We could also require some sort of a conservation appraisal at the front end that really appraises the proposed easement on a variety of levels. Also, there are proposals on the donee side to strengthen donee oversight. One is to empower the IRS to revoke the tax-exempt status for the failure to enforce the easement terms. Now, as I said earlier, there's really no consequence if a donee does not enforce the easement. At least there's not much of a tax consequence. Also, it's been proposed by the Treasury several years ago to impose excise taxes on officers of the donee for failure to enforce. Or there are proposals we could require that donees have sufficient funds to monitor and enforce, and some sort of a sanction for a loss of eligibility to receive further deductible contributions if they don't have enough set aside to monitor the easements that they have. So I suppose in summing up, I share Ted's initial remark that the goals here are widely shared and very important ones, and conservation values are what we're trying to get at and what the tax incentive is aiming to get at. The current incentive, though, at least in my opinion, is designed in a way that makes it very difficult to enforce and to secure those conservation benefits. Thank you very much.